Shalom, this is Yah is Magnified, and I'm back with another informative video. Today's video is titled, What Does the Court Hierarchy States? But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth, nothing more, nothing less. So with that being said, I would like for you all to hit that like button, and also, if you're new to my channel, hit that subscribe button, and also hit that notification bell so you all can be notified as I'm dropping these powerful videos. So without further ado, let's get to it. Okay, so I'm making this video in rebuttal to a video that I seen that recently popped up on my timeline pertaining to child support. And in the video, it had a bunch of false information in it. So because the information is false in it, I just want to give you all the correct understanding and what's really going on. But it's not going to be my words, guys. We're going to take it directly from the courts hierarchy to let the courts explain and rebut the nonsense stated in this person's video. So without further ado, let's play the video.
We're coming from, again, NJAC, and one of the lies that the unit perpetrates is that they have a set of what's called ens legis, which you know is creatures of law. They're created by the government or corporation. They are not created by spiritual realm. Okay. So right here under 110.4.1, it says custodial parents' rights. Okay. Now we know that's a lie because, okay, in Blessing versus Freestone, the Supreme Court for the United States ruled that Title 4D was not intended to benefit individual children and custodial parents, and therefore it does not constitute a federal right. So, if that being said, okay, why is the unit that operates in the state telling custodial parents that they have rights? On their website, they also tell the custodial parent that it has a right to these services. The child has a right to support, and it has a right to these services. Okay.
Okay, so now we're going to stop right here just for the moment. So did you guys catch it? I bet you most of you all didn't catch it. So let's go back and do it one more time. Let's listen one more time.
We're coming from, again, NJAC, and one of the lies that the unit perpetrates is that they have a set of what's called ens legis, which you know is creatures of law. They're created by the government or corporation. They are not created by spiritual realm. Okay. So right here under 110.4.1, it says custodial parents' rights. Okay. Now we know that's a lie because, okay, in Blessing versus Freestone, the Supreme Court for the United States ruled that Title 4D was not intended to benefit individual children and custodial parents, and therefore it does not constitute a federal right. So, if that being said, okay, why is the unit that operates in the state telling custodial parents that they have rights? On their website, they also tell the custodial parent that it has a right to these services. The child has a right to support, and it has a right to these services. Okay.
Okay, so did you guys just catch that? After hearing it the second time, did you guys just catch that? Majority of you guys didn't. I believe most of you guys didn't, if not all of you guys didn't. Why? Because the gentleman is so crafty, the way he talk, the way he speak, the way he even put his information out there or put the information out there. He's crafty in all his ways, guys. Also, the individual speaks with a forked tongue, okay? Just like a serpent. So you got to understand who you guys dealing with and what you guys are listening to when you listen to individuals on this internet. Understand, guys, do your own research. Don't take my word for it, his word for it, no one's word for it. Do your own research and come to your own conclusion. I'm just going to bring you guys the truth, and the truth shall do what, guys? The truth will set you all free, and it will make you free. Why? Because you now know the truth, and you cannot be deceived any longer. So now, the first thing he did was what, guys? He went to the New Jersey Annotated Codes. And once he went there, he highlighted it in red custodial parents' rights. So let's go there real quick. Let's go back to the beginning so you all can see what I'm referring to. Let's go back there. Let's break this thing down. Let's go. Okay, so now as you all can see, as I stated, he highlighted in red custodial parents' rights. Why did he do that? He did that to get you all to focus strictly on that term, custodial parents' rights. But as you notice, he didn't read anything below that. He stayed there and jumped immediately to blessings versus freestone. Why is that? Because he's going to use blessings versus freestone incorrectly to make you all believe that custodial parents have no rights, which is simply not true, guys. If custodial parents had no rights, then you wouldn't be in the situation that you're in right now, fighting against these people in child support, okay? So we're going to break down Blessed versus Freestone, but let's finish, let him read it so we can go back to where he left off at. Let's go back to the same spot we left off at. Let him go from there. We're going to stop it again. Let's go there.
So right here under 110 4.1, it says custodial parents' rights. Okay. Now we know that's a lie because, okay, in Blessing versus Freestone, the Supreme Court for the United States ruled that Title 4D was not intended to benefit individual children and custodial parents, and therefore it does not constitute a federal right. So, if that being said, okay, why is the unit that operates in the state telling custodial parents that they have rights?
Okay, guys, as I stated, he jumped directly to where? Blessings versus Freestone. Why is that? Because he's simply trying to make you all believe that custodial parents does not have rights, which is simply not true, guys, okay? The individual took one sentence from a whole case law and made a whole religion out of it, and he spread this religion around for years, and so many people are following the false doctrine, they all regurgitating the same line as if they know what they're talking about, when all actuality, these guys haven't read the whole case. They just simply did what? They simply regurgitating what the individual said from this channel, and that spread it around. Now everyone's regurgitating these same case laws. Blessed versus Freestone, Rehunt versus Ledbetter. We're gonna go over all of this, guys. We're about to break this thing down to a point of no return. And after I'm done this, guys, share my videos. Let's get this information out there, man. You know, I'm shadow banned, but I'm still applying that pressure. And I'm gonna apply more and more pressure. So now let's read that one sentence that he just read in its proper context. Let's read it. It states, Title 4D was not intended to benefit who, guys? Individual children and custodial parents. And because, so basically saying, because it does not benefit individual children and custodial parents, it basically states that, therefore, it does not constitute a federal right. And it's just that simple, okay? So, in order for you guys to understand that, you must understand what has transpired in Blacks versus Freestone. So, you have 5 women who try to sue Arizona Child Support Enforcement Agency and the United States District Court, and they took it all the way up to the United States Supreme Court on grounds that they didn't receive services according to the substantial compliance provided by the state program. Okay, but they not understanding substantial compliance is for everyone as a whole, not just for individual children and individual custodial parents. So, because substantial compliance is for the system as a whole and not the individual, then they lack individual rights to sue the agency underneath 1983. And it's just that simple, guys. And it's strange because, and I know why the individual's quoting this same case law, because they want you to believe that you can file a federal lawsuit underneath 1983 against the state, claiming that the child's mom doesn't have or the custodial parent doesn't have a right to collect child support, which is simply false, guys. This is how you break it down. To further prove that, let's read it from Blessings itself so you all get a better understanding of what I'm saying. Let's go there. Okay, so now as you all can see, we're coming from justdear.com. We're going to go over again, highlighted in blue, Blessings versus Freestone. And again, the reason why I'm going over this case is to put everything in its proper perspective, because I'm tired of individuals walking around or on these internet platforms claiming that they know something, regurgitating the case law out of context in order to deceive the people, to make people believe that they know what they're talking about in order for them to receive some type of funding from you. And that goes for all these internet gurus haven't won a thing. And those who claim to have won something, they only want from a technicality like extrinsic fraud. And the only reason why that is because the child was an adult by the time the case was over. If the child was still a minor, that person who's claiming extrinsic fraud and you want his case through extrinsic fraud, he would be on child support if the child was hands. They would have did a blood test and everything else. Only why they didn't do that and they didn't go for enforcement, because the child was no longer a child during that time that the court ruled that the case was underneath a stringent fraud, so they couldn't petition the court to have him pay child support because the child was no longer a minor, the child was now an adult. And it's just that simple. But these guys come around here bluffing and making it seem as though they doing something when they ain't done nothing. It's crazy, guys. But let's continue. It states, this picture's up at the top where it states respondents. And it reads, respondents, 5 Arizona mothers whose children are eligible for state child support services under Title 4D of the Social Security Act filed this 42 U.S.C. subsection 1983 suit against petitioner. So again, they filed what? 42 U.S.C. 1983 suit. The same suit that these internet gurus keep telling you guys to file, and they all are losing. To further prove me right, right? Will somebody please show proof of them winning? Not one person can show proof. Where is the proof? Where's the evidence? I showed you guys multiple evidence from multiple states of we getting state court remedy. Okay? So these guys need y'all to believe that you can win in federal court because they already admitted that they can't win in state court. So if they can't win in state court and they lost every federal court case, then what are they good for? They're not good for anything. They're simply there to try to convince you guys that they know something when they don't in order for them to receive financial gain from you to help you pay for their child support. And it's just that simple. And again, like I said, the one that uh uh did went off of technicality, he ain't doing nothing. He ain't won a thing. You see? He's filing Rick W paperwork, who also never won a thing. And it's crazy, guys, but let's continue. It states the director of the state child support agency claiming, among other things, that they properly applied for child support services, that despite their good faith efforts to cooperate, the agency never took adequate steps to obtain child support payments for them, that these omissions were largely attributed to staff shortages and other structural defects in the state's program, and that what, right here, guys, highlighted, and that these systematic failures, right, violated their individual rights under Title 4D. Now, guys, the systematic failure, that means the system itself. So because it's the system itself, it cannot grant you individual rights because it's for the whole entire system. And it's just that simple. So that's why they don't have any individual rights at this time, because it's a systematic thing. But let's continue. Let's pick it up. Let's keep it reading. It says to have all mandated services, let me scroll up, services delivered in substantial compliance. Again, there with that term, guys. What I tell y'all earlier, substantial compliance, right? With the Title 4D, excuse me, with the title and its implementing regulations. So again, guys, that has everything to do with the program itself. It has nothing to do with their individual rights. And that's a shame. But let's continue. This is the true breakdown of Blessings versus Freestone. This is not that fairy tale nonsense that these guys are saying online. But let's continue. It states they, right there, request broad relief, including a declaratory judgment that the Arizona program operation violates Title 4D provisions, creating rights in them that are enforceable through subsection 1983 actions, which is not true, guys. But let's continue. And an injunction requiring the director to achieve substantial compliance. Again, so they want the director, again, to do what? To achieve substantial compliance with the Title 4D throughout all programmatic operations. So again, guys, they're talking about this system as a whole, not individual rights. But let's continue. Then it states the district court granted summary judgment for petitioner, but the Ninth Circuit did what? Reverse. Uno reverse. They reversed it. But let's continue. Without distinguishing among the numerous provisions of the complex Title 4D program or the many rights those provisions might have created, the latter court held that the respondent had an enforceable individual right to have the state achieve substantial compliance. So that's why they highlighted it. I mean, that's why they put it in quotations. Substantial compliance, which means not individual, but as a whole. You see? But let's continue with Title 4D. And it's just that simple. But let's continue. Very top. It is also disagreed with the district court conclusions that Congress had foreclosed private Title 4D enforcement actions by authorizing the Secretary of Health and Human Services secretary to audit and cut off funds to states whose programs do not substantially comply with Title 4D requirements. But let's continue. Then it states held. So this is what the court held. Held. Title 4D does not give individuals a federal right to force a state agency to what? To substantially comply with Title 4D. That's all the case is about. Okay? It's just that simple. So, because they cannot force the state or give them individual federal rights to force the state to do anything, they automatically lost this case. But let's continue. Then it states a plaintiff seeks subsection 1983 redress must assert the violation of a federal right, not merely a federal law. Case law should support that. Then it states three principal factors determine whether a statutory provision creates a private enforceable right. Okay, so it has to be a private enforceable right. Okay, but let's continue. One, whether the plaintiff is an intended beneficiary of the statute, whether the plaintiff asserted interests are not so vague or amorphous as to be beyond the competence of the judiciary to enforce, and three, whether the statute imposed binding obligations on the state. Okay? Binding obligations on the state. There is no binding obligation on the state. Why? Because the state voluntarily entered into the 4D program. And it's just that simple, guys. Okay, but let's continue. Then it states, very top, highlighted in blue, even. Even if a plaintiff demonstrates such a right, however, there is only a rebuttal presumption that it is enforceable under subsection 1983. Okay, then it states dismissal is proper if Congress specifically foreclosed a subsection 1983 remedy. Okay, so because Congress foreclosed the 1983 remedy, that means nobody's going to ever win a 1983 lawsuit against the state, its agents, or its actors in these federal courts. And it's just that simple. How many times I have to say this? But let's continue. Then it states either, right here, highlighted in blue, then it states either expressly or, excuse me, then it states either, highlighted in blue, expressly by forbidding recourse to subsection 1983 and the statute itself, or impliedly by creating a comprehensive enforcement scheme that is incompatible with individual subsection 1983 enforcement, guys. So again, it's easy. It's easy to do. So now that we went over that, let's go back to the other side of this video and let's continue to rebut that as well, guys. We're going to eat these cats alive. I'm going to show you all it's levels to this. Like Meek Mill say, it's levels to this, and I'm on the highest one. But let's continue. Okay, so we just rebutted his first lie. Let's continue to hear him out so we can rebut his second lie. Let's continue on, guys. We're going to keep applying that pressure. Let's continue.
Now, therefore, does not constitute a federal right, far from creating an individual entitlement to services. 42 USC 601, there is no entitlement to any services that are funded by the federal government. Thus, the Secretary must look to the aggregate services provided by the 4D unit. Now, it says provided by the state. The state does not provide these services. The 4D unit does, and pursuant to its 45 CFR 301.10 plan, point 10 plan, it is the instrumentality of the federal Office of Child Support Enforcement, which is within the United States Department of Health and Human Services. All right. It is not a state agency.
Okay, so y'all just heard it. Did y'all catch it? I'm gonna ask again. Did you guys catch it? All right, I'm gonna let y'all hear it one more time. Then I'm gonna come back and expose the second half. Let's continue.
Therefore, it does not constitute a federal right, far from creating an individual entitlement to services. 42 USC 601, there is no entitlement to any services that are funded by the federal government. Thus, the Secretary must look to the aggregate services provided by the 4D unit. Now, it says provided by the state. The state does not provide these services. The 4D unit does, and pursuant to its 45 CFR 301.10 plan, point 10 plan, it is the instrumentality of the federal Office of Child Support Enforcement, which is within the United States Department of Health and Human Services. All right. It is not a state agency.
Okay, so now you guys just heard that for the second time. Did you guys catch that? I'm gonna ask again. Did you guys catch that? All right, let's get to it. Okay, so he's so crafty. It clearly says state, but he wanted to say it doesn't say state or it's not a state agency. But then he wants to quote or use what's written right above it to say that's true, but then when he get below that, he say that's false. It doesn't make sense, guys. That's a snake, forked tongue, guys. Okay? If it says state, it means state. Okay? To further prove that, let's go and see what the hierarchy says. Let's go to multiple case law. So we're going to see who's right and who's wrong. He says not a state agency. Let's see what these courts rule. Let's go there. Okay, guys. As you all can see, we're coming again from the United States Supreme Court, the highest court of the land, which is the highest of the hierarchy. Let's read it. Again, we're coming from the same case again. Blessings versus Freestone. It doesn't say it, it says it multiple times in that case. But let's go over it again, because the scripture says, out of the mouth of two or three witnesses, let each matter be established. So again, the same case, but in a different place further down than what we covered. But let's continue. It reads what? Quote, Congress created the Child Support Enforcement Program, Part D of Title IV of the Social Security Act, Title 4D, as a what? As a cooperative federal state program. Participating states are required to establish paternity, locate absent parents, and obtain child support payments. In return, the federal government pays 2/3 of the state's administrative costs. Now, that's the agreement, okay? So you have the state-ran program underneath the federal what? Federal guidelines. And it's just that simple, guys. But let's continue. Highlighted in yellow. Recognizes child support enforcement is what? Is administered through state agencies as part of a cooperative system. And it's just that simple, guys. So now let's go to the next one. Let's go to the next case law. Let's go down. So now we just did the U.S. Supreme Court. Now let's do the U.S. Courts of Appeals. Let's read those case laws. Let's go there. Okay, so now as you all can see, we're coming from the U.S. Federal Courts of Appeals, and it reads, we're coming from straight from another case law that these same individuals like to quote. Again, it reads, We Hunt versus Ledbetter. Georgia Department of Human Services, acting through its child support enforcement section, is what? It's an arm of the state and thus entitled to 11th Amendment immunity. So when it states an arm of the state, it means it's a state agency because it's an arm of that state. And it's just that simple. But let's continue. Williams versus the state of Utah. And it reads, Utah Office of Recovery Services Child Support Division is what? Is an arm of the state entitled to what? 11th Amendment immunity. The same thing, guys. But let's continue. Harris versus Missouri Department of Social Services Family Support Division. And it states, the Missouri Department of Social Services Family Support Division is a state agency that what? That functions as an arm of the state and is immune from suit under the 11th Amendment. So again, guys, out of the mouth of two or three witnesses, let each matter be established. So we have the U.S. Supreme Court. Now we have the Federal Courts of Appeals. That's two witnesses right there. Let's make the third witness going to be what? The United States District Court. Let's go there. Okay, so now this is the Federal District Court. The third witness, like the scripture says, let out of the mouth of two or three witnesses, let each matter be established. So this is the third witness to testify on my behalf. And it reads, Verrier versus Puerto Rico, and then it states Puerto Rico's administration for child support is what, guys? Say it with me now. An arm of the Commonwealth and what? And enjoys 11th Amendment immunity. Again, the same things is being said. Also, there are multiple cases I can put up, but I'm just only putting these up just to prove a point. But let's continue. It states Hines versus Mississippi Department of Human Services, and it reads, the Mississippi Department of Human Services Division of Child Support Enforcement is what? Is an arm of the state and what? And not subject to suit under 1983. And it's just that simple, guys. But let's go one more. We said all that in what? In federal. So we're done with the federal court. All three federal jurisdictions, we're done with those. So now let's put the nail in the coffin and let's go to state court. Let's go there. State courts. The fourth witness to testify on my behalf, and it reads State Ex Rel Hermes versus Saver, and it reads Title 4D establishes a cooperative federal state program in which the states, through designated agencies, provide support enforcement services subject to federal requirements. That's all it is, guys. It's subject to federal requirements. Basically, subject to federal statutes and codes, or federal guidelines, should I say. But let's continue. Then it says in remarriage of Malak, and it reads The Illinois Department of Public Aid, Child Support Enforcement, is a state agency acting on behalf of what? Of the state. So again, guys, I can go on all day simply proving these cats wrong, but that's all I'm gonna do for today. If you all need my help, hit me up at my email at y'allismagnified@gmail.com, guys. We can't play no games. We gotta get this false information off the internet. I know it's gonna be impossible to do because these guys are professional scammers. But as long as I'm here, guys, I'm going to give you all the truth as long as I can provide it. And I'm going to continue to provide that truth. So with that being said, you all be blessed. If you need my help, hit me up at my email at y'allismagnified@gmail.com. Let's get this right wisdom, this right knowledge, and this right understanding. With that being said, I say shalom.